Good day, everybody. This is Karen Booth, a partner in the Washington, D.C. office of Thompson Hine and chair of the Transportation Practice Group. On behalf of the entire transportation team at the firm, I would like to welcome you to today's webinar regarding how to prepare for the Surface Transportation Board's hearing on railroad demurrage and accessorial charges. Before we begin, I would like to review a few preliminary matters regarding the webinar logistics and materials. Today's program is being recorded and will be available on our website within a few days after the webinar. We also will send out our webinar slides by email to the attendees later today. During the webinar presentation, all attendees will be muted, but we strongly encourage you to submit your questions to us. You can submit questions by typing them in the question box on the side panel on your computer screen. We will be addressing your questions after our presentation. If we are not able to address your question during the presentation, we will follow up with you after the webinar. Now turning to the program. There's a paradigm shift happening in the freight railroad industry whereby nearly all Class I railroads are changing their operating models to implement aspects of precision scheduled railroading, otherwise known as PSR. As part of this process, the railroads have adopted changes to their tariff rules governing free time, demurrage, and accessorial charges. The combination of these operational and tariff changes is creating many challenges for rail customers, including decreases in rail service and substantially rising demurrage, storage, and other costs. The STB has scheduled the hearing on May 22nd in Washington, D.C., in order to hear directly from the railroads regarding the basis for the changes to these demurrage and related practices, and from rail customers regarding the impacts of these changes. In fact, the Class I railroads have been directed to appear at the hearing and to provide specific information to the board in advance regarding the tariff changes, revenue collected from demurrage and accessorial charges, and other fairness-related concerns. To help rail customers prepare for the hearing, we plan to address the following topics during today's webinar. First, Sandy Brown will provide some background information on demurrage and accessorial charges, as well as the STB's jurisdiction over such matters. David Benz will then address some of the changes to railroad tariff rules and charges and to their operations that have resulted from PSR implementation. We will then turn to the STB's hearing, and Jason Tutrone and Jeff Marino will outline how companies can approach their testimony, including topics to be addressed at the hearing. And finally, I will cover some possible outcomes of the hearing and requirements for participation. So that concludes my introduction, and you can see we have a lot of information to cover. So I will now turn the program over to Sandy Brown to address our first topic.
Great, thanks, Karen. Well, first, we'll talk about the demurrage. So demurrage is a term that's often used interchangeably for cars being held or constructively placed where there's a charge being made for that. The STB also sometimes uses demurrage when it's referring to railroad cars or private cars. But demurrage is technically a charge for railroad-owned or railroad-controlled cars that are detained beyond a free time as applicable for example, loading or unloading, and the shipper can't take the car. Storage is technically a term for private cars that are held on railroad property, again, beyond any applicable free time. Storage can also, of course, be where you are really storing your cars on storage tracks. Accessorial charges is a charge that's separate from the transportation service for like weighing, interplan switching, and charges like that. And the railroads, of course, have various tariffs that set out various charges for these types of charges. So next slide, slide 6. Demurrage and accessorial principles. So the STB has jurisdiction over demurrage, accessorial charges and rules that are in tariffs. They do not have jurisdiction over them when they are in contracts. And that includes when the provision is incorporated by reference into a contract. They do not then have jurisdiction over that contract and incorporated tariff provision with respect to that specific movement covered by that contract. The statute requires that demurrage and accessorial practices must be just and reasonable. And just and reasonable is a term that is used in a lot of different STB contexts. It's very fact-specific. The termination is looked at really on a case-by-case basis. And Karen will talk a little bit later about some of the outcomes of the hearing that also play into this just and reasonable principle. So the functions of demurrage and the reason why the STB statute regulations and precedent talk about why is demurrage and storage charges permitted by the railroads. And they are permitted to compensate the railroad for use of its equipment and infrastructure. But they're also permitted as a penalty to incentivize efficient use of rail cars and railroad infrastructure. But what the precedent is very clear is that it cannot be used by carriers principally as a revenue source. And I think some of those concerns are what are leading to the hearing today. So I'm going to turn it over now to David Benz.
Hi, yes, this is David Benz. I'm on slide 7 now. I'm going to talk briefly about some of the new railroad charges that are being implemented recently, some of the rule changes that have been made recently that are causing a lot of the impacts that rail customers are seeing. Again, these are just some examples of some that we have seen in the industry. There are lots of other rule changes and new charges out there, and the ones we're going to talk about, not every shipper may have seen the ones we're going to talk about, but we're going to try to focus on some of the bigger ones we've seen lately. So the first one is free time reductions. Now, if you reduce the amount of free time applicable to a shipment, then the demurrage and storage charges will kick in much earlier. Now, the terminology is not necessarily the same for all railroads. For example, Norfolk Southern, if you look at their tariff, they use the term credit days instead of demurrage. Now, historically, 48 hours was a common time for free time that we saw for many years in the industry, depending upon various circumstances like who owned the car, the type of commodity, whether it was loading or unloading. But recently what we've seen is that a lot of railroads are moving from 48 hours down to 24 hours or even 0 hours, no free time whatsoever. So that reduction is having an impact on lots of different parties. Again, the specific free time depends on factors like the commodity, who owned the car, whether you're loading or unloading. But these impacts are especially felt on facilities that are closed gate facilities or that do not operate 24/7. They're seeing big impacts from a reduction in free time. Now, another change we've seen recently is this Norfolk Southern congestion charge. This charge applies when an excessive number of cars congest Norfolk Southern facilities, causing material operating problems for NS. Now, as you can see, these terms are greatly open to interpretation. You've got terms like excessive and material. The tariff also says NS's sole discretion will determine when this applies. Now, the charge is $100 per car per day for each car over 2 times the average daily cars in the previous 2 weeks. Now, this is a recent change, this 2 times figure. It had been 3 times prior to January 2019. So this recent change just a few months ago, it really reduced flexibility for rail customers before the charge kicks in. So I'm going to switch to slide 8 now and give a few more examples. We're also seeing increased switch charges. Now, this would have the greatest impact on rail customers that use offsite storage. Of course, a big reason to use offsite storage is if you don't have enough free time. So if free time is being reduced, parties are trying to use offsite storage, but now they're getting hit with a switch charge. So you're trying to avoid one charge, but you're getting hit with a different charge, switch charges. Another recent change we've seen is this UP charge called Not Prepared for Service. Union Pacific has actually had a provision in their tariff sort of like this for a few years, but it formerly was not called not prepared for service, and it only applied in one specific scenario. That's when rail cars were released empty, but in fact they were not empty. But now UP has created this new name, not prepared for service, and they've given a list of six different scenarios where this applies. And it's things like cars that were released by a shipper, but they're placed in a spot that's inaccessible to UP in UP's view. So the charge here is $400 per car, again, at 6 different scenarios. And finally on this slide, Mexico cross-border movements. This is a new rule change, January 2019. This charge applies when cars are headed to Mexico if customs clearance has not been received within 24 hours of the disposition instructions for origins of Texas, Louisiana, Arkansas, or within 48 hours for all other origins. UP will not pick up the unreleased car, and UP may assess the unprepared for service charge in addition to the charge itself for this tariff, which is $300 per car. So we are going to switch now to slide 9, and I'm going to switch gears just a little bit. I'm going to give some examples of operational changes that the railroads are making. So they're not just changing tariffs and rules and charges, they're also making some operational changes and describe some of the impacts that some rail customers are seeing from these operational changes. Now, the big operational change here is precision scheduled railroading. As Karen mentioned, this is called PSR. It's a sort of an amorphous term that can mean lots of different things. But really what it means is railroads are trying to operate more on a scheduled timetable. Now, the recent PSR push began in 2017 with CSXT. There were widespread problems when CSXT implemented PSR a couple years ago. But now we're seeing Norfolk Southern and Union Pacific and other railroads are also moving toward PSR, though we haven't seen BNSF make this effort yet. Now, in addition to PSR, we're seeing some customers are reporting to us local service reductions. Now, this could be related to PSR because one of the big reasons behind PSR is to reduce costs, and reducing costs includes reducing locomotives and reducing crews. Of course, if you reduce locomotives and crews, you may be also reducing the number of trains. Something else we're seeing is bunching reported by many rail customers. And of course, here we've got an inherent conflict between a railroad desire for fewer trains, maybe fewer larger trains. It makes it a little less costly for them. But of course, rail customers want more frequent and reliable service. So there's a little bit of a conflict there. And if railroads are moving toward PSR, we may see more bunching. Another thing that rail customers are reporting is a large variability in transit time. This perhaps is not a surprise because if railroads are trying to operate on a scheduled timetable, rather than when shipments are ready, then those shipments are going to have widely varying transit times. And finally, on this slide, storage track issues. We've heard that some railroads are canceling storage track leases or raising the rates for storage track. And again, this may be part of a railroad desire to keep everything moving at all times, reduce the number of stationary cars, or just dissuade customers from having extra private cars. So I'm going to switch to slide 10 now and talk a little bit about enforcement, just briefly. Now, rail operations are complex. I think we would generally all agree with that. But what's also complex is the operations of rail customers. Rail customers operate a wide variety of facilities, from manufacturing to processing to warehousing to other things, and transportation just plays a small part in the rail customer operations. Now, when you have complex rail operations trying to mesh with complex rail customer operations, that itself is a complicated process. It requires lots of ongoing coordination, communication on a daily, if not hourly basis. Now, as that ongoing coordination occurs, there may be a variety of situations where possibly a railroad tariff charge could be triggered, maybe, depending upon the circumstances. But historically, what we've seen is that railroads haven't always made an effort to investigate every possible scenario where a charge might possibly apply, because it's just too complicated and takes too much effort to figure out who may have been responsible for a particular situation or who may have caused a particular delay. But now what we're seeing the past 6 or 9 months is that railroads are really applying their charges and fees whenever they're remotely plausible, remotely possible, regardless of making any effort to definitively find out who is responsible for a charge or delay. So that's a big enforcement change we've seen recently. So now I'm going to hand it over to Jason. He's going to talk a little bit about preparing testimony for the upcoming Surface Transportation Board hearing.
Thank you, David. Because of the types of changes that David discussed, the board has organized a hearing to obtain information about the railroad's current demurrage and accessorial practices. This hearing is an important opportunity for rail customers to share their real-world experience with these practices. Keep in mind, the board does not see firsthand how these practices play out. Your testimony can provide that insight. On this slide, we provide a high-level outline of how to share your experience. First, provide background about your company and its use of rail service. This will provide the board with the context it needs to understand the importance of demurrage and accessorial practices on your business as a whole. Second, provide an overview of your recent experience with railroad demurrage and accessorial practices. On the coming slides, I'll provide you some more details on what to include on this topic and on the following topics. Third, provide details on the key railroad changes driving your increased exposure to demurrage and accessorial charges. Finally, identify reciprocal railroad obligations that would enhance the commercial fairness of demurrage and accessorial charges. Before we move to the other slides, I want to point out something that's very important. Include, to the extent you can, specific examples of your real-world experience. These examples are the board's window into what's happening on the ground. So let's talk about providing the board with an overview of your experience. Starting with implementation, discuss the extent to which railroads implemented changes to their demurrage and accessorial practices faster than you could respond. We understand that many changes were implemented on 45 days notice. For many rail customers, this was not enough time to avoid the resulting demurrage and accessorial exposure. Customers had to make significant operational adjustments, including acquiring additional storage space, adjusting staffing and production, or upgrading infrastructure. In some cases, customers had to redesign long-standing operations that they had developed to avoid charges under the previous rules. If your experience was similar to this, let the board know. Also, identify how transition assistance from railroads was inadequate. We've heard that during the transition period, some customers approached railroads seeking clarity around changed rules or suggesting mutual operational adjustments that would be a win-win for both the customer and the railroad, but the railroad didn't respond. This indicates unreasonableness and should be brought to the board's attention. Similarly, if after the railroads implemented their changes, you tried to collaborate with them on avoiding charges and they resisted those attempts, let the board know. Also, identify whether railroads have not been willing to enter agreements addressing demurrage and accessorial concerns. This would suggest that viable commercial solutions to demurrage and accessorial issues do not exist. You also should identify any additional shipment information you need from the railroads to make informed decisions about adjustments that would reduce your exposure to demurrage or accessorial charges. If you don't have the information you need to avoid a demurrage or storage charge, then the charge doesn't fulfill its purpose of incentivizing conduct, which indicates unreasonableness. Similarly, if the railroads do not have adequate processes or tools in place to enable you to order in or release cars during free time, or otherwise manage events leading to demurrage or accessorial charges, let the board know. This would suggest that the railroads want to protect the revenue that they get from these charges, which is a sign of unreasonableness. You should also address inadequacies with the railroad processes for disputing demurrage and accessorial charges, or their processes for requesting credits. Identify railroads that do not have a clear process. Identify deadlines that you feel are too short. Some railroads only provide 30 days to dispute a charge. In other cases, they may even charge you $500 if you don't dispute a charge within 5 days of the end of the month, despite you meeting the 30-day requirement. These types of issues indicate that the railroad is looking to protect a revenue stream, which is not the point of demurrage. Similarly, identify the extent to which railroad data are insufficient for you to validate charges or determine whether you are entitled to credits. Without adequate data, you will be unable to dispute a charge or ask for credits that are owed. This would be a sign that the railroad is looking to protect a revenue stream. Also, provide specific examples of difficulties you've had disputing demurrage and accessorial charges or requesting credits. Many railroads have rules and processes in place for disputes, and the board can see those. But what the board can't see is whether the railroads are following them and are acting in a fair manner. Your examples will help the board understand how disputes actually work. Similarly, provide examples of railroad refusals to address your claims by participating in voluntary dispute resolution programs. The board provides various dispute resolution programs and encourages parties to use these programs before seeking formal board intervention. If the railroads are refusing to participate in the programs, it would signal that these programs are not viable solutions for shippers and that railroads are trying to protect their revenue. Now, I'll turn it over to Jeff to talk about providing testimony on key changes and reciprocal railroad obligations.
Thank you, Jason. As Sandy Brown mentioned at the outset of this webinar, railroad practices related to demurrage must be reasonable. And reasonableness is also a factor of whether the demurrage rules and practices actually serve the functions and purposes of demurrage, which, as Sandy related, are to compensate the carrier for the use of its assets and to incentivize the shipper to make a more efficient use of railroad assets. Therefore, a strong indicator of reasonableness is whether the tariff actually encourages more efficient behavior in the way the shippers utilize railroad resources, such as rail cars and track space. If conditions, however, make it difficult for a shipper to avoid demurrage charges through their behavioral changes, that is a strong indicator that the charges are not in fact serving this purpose and consequently are little more than a revenue generator for the railroads, which is unreasonable under board precedent. Therefore, one of the principal points that you should encompass within your testimony, if applicable, is to explain why it is difficult or impossible for you to avoid demurrage or storage charges under the new rules. Bunching, for example, is a very common reason. If railroads deliver cars to you in bunches despite your attempts to spread them over time for more even deliveries, your facility may not have the capacity to accept all of those cars at once, resulting in unavoidable demurrage or storage charges. Most railroads do, however, provide credits to offset those unavoidable charges when they are responsible for the bunching. But sometimes railroads may make it difficult to obtain those credits, and any such difficulties are facts that the STB would be interested in learning about. Also, railroads typically do not provide credits for bunching by upstream connecting carriers, because those cars are already bunched when the delivering railroad receives them from the upstream railroad at the interchange. As a result, the railroad considers that it is not responsible for the bunching and therefore doesn't owe you any credits, even though you too are not responsible for the bunching. Another factor is reduced rail service. If a railroad has reduced its service frequency, resulting in additional demurrage charges, that would be unreasonable. Some railroads provide credits for the days they do not switch a facility to offset those additional demurrage impacts, but other railroads may not. If you are required to rely on remote storage sites to avoid demurrage charges, another service issue is whether you can obtain your cars in a timely manner when requested, or are you faced with delayed switches that impact your operations and perhaps impose more demurrage and storage costs upon you. Similar to service reductions, service failures can result in paying more demurrage or storage fees. A common thing that occurs is missed switches and failures to deliver cars when ordered. Those are common service failures that can cause you to incur more demurrage and storage fees than otherwise would occur. If railroads do not give you credits when these service failures occur, that would be unreasonable, and it's a factor the STB would be interested in hearing about in your testimony. Another key factor is the difficulty in acquiring storage. In many instances, the only way to avoid these new demurrage or storage charges is to acquire storage at remote locations. But such storage may not be available at all in reasonable proximity to your facility, or it may be available only at a very high cost. Furthermore, often those remote storage locations are provided by the same railroad that is imposing the demurrage charges. A common theme that we're seeing is that those railroads either are canceling their current track leases or they're substantially increasing the rent. Thus, whether you're paying demurrage charges or switching charges or track lease charges, you're paying more overall to the rail industry, which could be indicative of this being more of a revenue generator than an operational improvement strategy on the part of the rail industry. In some instances, the difficulties you have complying with the new rules could be mitigated if the railroads made certain operational changes. For example, more frequent switches or better information on car status while in transit might help you manage the flow of cars through your facility better. To the extent that these or any other changes would facilitate your ability to comply with the new rules, this should be included in your testimony. The STB also has expressed a very strong interest in what it calls reciprocity or commercial fairness. In letters to each Class 1 railroad last fall, the STB chairman, Ann Begeman, asked each railroad to explain whether and how their demurrage and accessorial tariffs actually fulfilled these reciprocity and commercial fairness objectives. This is a new concern that has not appeared in the agency's legal precedent on such charges, except to the extent that a railroad may not assess such charges when its service failures are the cause. In response to Chairman Begeman's letter, the railroads essentially adhered to this narrow precedent by taking a very narrow view of reciprocity and commercial fairness. They asserted that their tariffs are reciprocal because they provide credits when they are the cause of bunching that prevents a shipper from accepting the bunch cars all at once. Also, they pointed out that their tariffs provide credit for weather-related delays, such as frozen lading that prevents a receiver from promptly unloading a rail car. I believe, however, that Chairman Begeman had a broader definition of commercial fairness in mind that more closely aligns with the definition that shippers have been seeking for many years. Many of the new demurrage, storage, and accessorial rules and charges are targeted at shipper behavior that disrupts rail operations. For years, shippers have complained about a lack of reciprocity when railroad behavior disrupts their operations. Examples include missed early or late switches, a failure of the railroad to deliver cars when ordered, holding their cars for delivery, and bunching on upstream carriers. Your testimony would be a valuable source of information for the board to give examples of these and other railroad-caused disruptions for which you believe railroads should compensate you within the concepts of reciprocity and commercial fairness. The STB also would welcome any suggestions you have as to what form these reciprocal obligations should take. Examples include credits for bunch cars regardless of where the bunching occurs, so long as the receiver, you, are not the cause. Waiving a charge while the shipper is making infrastructure investments. This would be designed to give you more time to adjust your operations to the charges and the changes that the railroads have made. Also, providing additional free time at facilities that do not receive daily switches. And any other ideas that you may have that are specific to your individual experience would be informative for the board as part of your testimony. Since some railroads may already be doing some of these things, it will be important to single out those that are not doing so. Even railroads who are doing some of these things, however, may not make it easy for you to obtain credits or refunds. In those cases, the STB would like to know your suggestions for making the process easier. This sums up our content suggestions for shipper testimony at the May 22nd STB hearing. I'll now turn it over to Karen Booth, who will discuss the potential outcomes from that hearing.
Great. Thanks very much, Jeff. So, at the end of the day, I think there is obviously a lot of interest, and once the board collects all this information from both the railroads and the shipper communities, what is it likely to do? What actions might it take? And, we don't have a crystal ball, but I think based on our experience, we have some ideas as to possibilities and ways the board may proceed. So one of the things the board could do is it could use its investigative powers to initiate an investigation as to whether some of these changes in the demurrage and accessorial practices actually do violate the law. And this is a relatively new power that the board obtained from Congress at the end of 2015. But there are some parameters that apply to this investigative power. And that is that the violation that the board investigates needs to be of national or regional significance. That's a standard in the statute, and there's no definition of that. But it's something that the board would determine on a case-by-case basis. But some of the factors they would look at is essentially what is the geographic scope of the issues and the problems and the potential violation, as well as what are the impacts on rail traffic and on customers. And we think here, given the very breadth of PSR implementation and the breadth of changes across the industry in tariffs, that would likely meet the standard if the board decided to go in this direction. I guess similarly, though, it's important to emphasize that this power is not likely to be used to investigate individual railroad shipper disputes. And that may disappoint some folks, but in general, this is not intended to be a complaint-specific type of power, but again, something that's of broader scale. Another action the board could take is it could initiate a rulemaking to adopt rules to address some of these commercial fairness concerns. There are existing demurrage rules on the books, but today they don't address the types of issues we're seeing here, and again, commercial fairness issues, which is the focus, or appears to be the focus of the board's hearing. And part of that is that, again, the reasonableness standard we're talking about, you've heard it's a very fact-specific legal standard, and that does make it challenging and difficult to adopt hard and fast rules that can work in every scenario. But having said that, we do think that there are potential areas that the board could adopt rules, and one would be in the area of dispute resolution. There could be standards adopted for a claims process. We've heard that there are different rules that the railroads apply. They're not always applied consistently. I know I've talked to some individual shippers who have indicated that, frankly, in some of these instances, trying to resolve demurrage disputes has been a nightmare, very resource intensive, very lengthy in time, requiring escalation. And hopefully, this could be an area where some efficiencies and clarity could be adopted through new rules. Additionally, a rulemaking could be effective to deal with railroad data that is necessary to decide whether or not a charge is valid. And we've heard Jason and Jeff talk to some extent about the application of credits. Again, you need information and facts to be able to determine who's at fault, who caused the delay. Is it appropriate, to assess the demurrage charge or abate the charge or apply a credit? And so again, the board could potentially address those types of issues through rulemaking. Yet a third action, and I guess they could even take a combination of these, would be moving in the direction of not a hard and fast rule that's enforceable through civil penalties, so to speak, but rather a policy statement. And a policy statement is different from the standpoint that what that does is it establishes guidelines. It can be enforcement guidelines. And here we think it could be something where the reasonableness standard could be fleshed out through principles that essentially allows the industry to self-regulate on some of these issues. And again, because of the need for case-by-case analysis, having some principles or guidance could be very helpful. And they would not be, again, enforceable as a matter of law, but even if a dispute arose and a complaint was filed at the board regarding a demurrage dispute, these principles and guidelines could be used as an effective tool to assist in adjudicating those disputes, which could reduce the time and cost involved as well. Now, what the board is not likely to do as a result of this hearing is to issue reparations or provide money back to potentially aggrieved rail customers who may believe they've overpaid in demurrage, who believe the unfairness standard should be met. And that's because the board has no power to do that in a public hearing. That requires a formal complaint to be filed. It requires evidence to be submitted. And only after a formal adjudication could the board issue an order of that type where they return money for a violation of law to a specific company. Next slide. So now turning to just some logistics information and deadlines about the hearing itself. As we've stated, the hearing is going to be on Wednesday, May 22nd. It's going to start at 9:30 in the morning. It's going to be in Washington. It's not at the STB. The STB is undergoing some renovations. So this hearing is going to be down the street at the U.S. International Trade Commission. We do recommend for those folks who plan to participate that you arrive 30 minutes early. All government agencies do have security clearances. We do expect this will be a very well-attended hearing, so there'll likely be lines to get in and get situated. There also are some deadlines that you need to be aware of. April 24th, just a week from today, any party that wants to appear at the hearing needs to file a notice of intent with the STB. It's a very short filing, and that notice of intent needs to identify the company representative or representatives, if there's more than one, who will be speaking, and then to ask for a specific amount of time for your testimony. I would say on average that time is usually 10 minutes. It can be 5 to 15 as well. But the STB will eventually issue an order, a few days before the hearing that will actually list all the participants and allot the time that you will get. You may or may not get the time you ask for, but that notice of intent does need to include a time request. And then lastly, on May 8th, parties who plan to appear at the hearing need to submit their testimony to the board in advance. This helps the board members and their staff prepare for the hearing. They will ask questions at the end of testimony, so you may want to think about that. And even if you do not plan to come to Washington for the hearing, maybe you have a conflict, maybe you just don't want to do that, you can still submit written comments on these issues to the board. And again, that would be due by May 8th. So just a couple additional thoughts here, and then we'll turn to any questions. And if you haven't submitted questions yet, we encourage you to do that. But I did want to also mention this hearing will not be live streamed. Most STB hearings are, but again, because it's not at the board, there will not be a live stream for this particular hearing. And so that concludes our formal presentation for all of you. We will turn to questions. I think we have a couple that maybe have come through while I was speaking. So let me turn it over here to some of the others here who have that. Okay, and so what I'm being told is that we have comments that have come in, but no formal questions. Just to kind of share information, in some cases we hear the railroads have expanded service, so it's not always a reduction. It can be PSR resulting in reduction or expansions of service. Good point. That's true. Hopefully you're one of the lucky customers who's getting more service. And I think we have another comment here, but it's really more just an individual circumstance of a company that is expressing their unfair practice, but there's no question. And so I think we would rather not read this scenario to the attendees. So we're going to ask one more time to see, we do have a question. How will I know from the STB that they have approved my time at the hearing? Again, the board will issue an order after the deadlines here, after they receive all the testimony, that will list all of the speakers at the hearing, and in that order, it will include the time allotment for each speaker. In some instances, they may put you on a panel of speakers. They likely will do that. They often will combine railroads in one panel, shipper interests in another, companies in one panel, association reps in another.
Grouping the companies by industry in many instances. I think it's also important to understand the STB has a practice of allowing witnesses to read their entire testimony uninterrupted. Rather, if they have any questions, they will hold their questions until every witness on the panel has spoken. Typically, a panel will be comprised of anywhere between 3 to 5 witnesses sitting at a dais up at the front of the boardroom, and each individual will be allowed to go along and give their complete testimony, and then the board will ask questions of the entire panel at once.
Again, we have time here, so feel free to send us your questions. Another question came in about availability of the webinar and presentation. We will be sending all participants, attendees here, our slides later today by email. And this is being recorded, so it will be posted on the website in a couple days if you have colleagues who couldn't attend but want to hear the recording.
We have a question as to whether the STB views the actions of short lines in the same manner that they do the Class 1 railroads. I think the focus of this hearing clearly has been the Class 1 railroads, because that's where most of the changes have been coming from. But to the extent that short lines are also involved in some of these changes that are having impacts, I think the STB would be interested in knowing that, because at the moment, I don't believe their focus is on the short lines. Another question we've received is, how can we be sure that the railroads will be honest about the benefits they have seen from their new practices and not hide it? For instance, this particular questioner says they have not agreed to pay any invoices yet, so they may not want to come clean if they are reserving for any of this. That's a good question in terms of the benefits, because in order for these new rules and practices to be reasonable, and particularly the free time, there has to be some benefit that the railroads are getting out of this. And thus far, the railroads have only made very broad claims that they're doing this for PSR in order to decongest their systems and run more efficiently. But we've yet to see the results of that, yet the railroads are already collecting these demurrage charges. I think this will be in line of questioning that the STB will have of the railroads at the hearing. And part of the purpose of this hearing is to get some information on this. Whether or not the railroads are going to be honest about this, I think ultimately the statistics are going to be the proof. And the STB is asking the railroads to provide significant information in advance of the hearing, and they are also requiring periodic reporting on a quarterly basis of the revenues the railroads are obtaining from this. If these performance improvements do not materialize, I think the STB will have heightened concerns.
So another question came in. It's how would STB suggest we deal with the receiving carrier of bunched cars that got bunched by the Class 1 that handed off to them? Now, as we indicated during the presentation, we're hearing a lot about bunching. It seems to be a particular area of concern based on the changes that have been implemented. And I guess a couple points here. One, the STB itself has identified this issue as one of the ones that it wants to hear about from rail customers at the hearing, both in terms of the extent to which it's happening, descriptions about the impacts, and whether it involves the delivering carrier or an upstream carrier. They specifically asked about upstream bunching as well. They have not yet, to be directly responsive, indicated how they may address this point. I'll tell you, however, that in the recent, 4 or 5 years ago, when the board adopted its current demurrage rules, they avoided the bunching issue in that rulemaking. We specifically were representing an association who asked the board to address bunching. But at that time, while it was a concern, it wasn't to the same extent that we're hearing about it now. So it's hard to say whether the board will specifically address it through some formal action, but they certainly want to hear about it, and it's possible that they will do that. And frankly, if it's a big concern, we encourage testimony that not only describes it, but asks the board to do something about it.
I would add on top of what Karen has responded that there was a very recent decision by the board in which bunching was at least one of the complaints the shipper had made against a short line railroad, in this case the Utah Railroad. And the STB did acknowledge that bunching is a concern. They did not grant relief in that case, but it was because the shipper did not present evidence of specific bunching that they could link to the demurrage charges that were assessed. Rather, the board said you cannot make generalizations of bunching. You have to link the charge you're challenging to specific bunching events. So that signals the board is willing to address this on a case-by-case basis, as we have discussed.
Another question has come in. It says, is it possible the STB could limit storage and congestion charges to, for example, half of what they are trying to impose? This question raises the issue of whether a charge for congestion, et cetera, is an unreasonable practice, or is it an unreasonable charge that's challengeable more under the rate reasonableness and charges jurisdiction of the board, which is separate. The railroads may view this more as a rate reasonableness issue, and frankly, I think the board is not, as a result of this hearing, going to be addressing specific charges, reducing the amounts of charges, even if on their face they may appear to be relatively high. That would require an adjudication, perhaps under the rate reasonableness jurisdiction of the board. And frankly, it's a so deeply commercial point that I think the board generally doesn't like to be setting those charges.
We have a question as to whether we had indicated all class 1s are moving to PSR, and whether that means we're likely to see examples of what UP did with its manifest service being applied by other railroads. Most of the class 1s, BNSF has clearly said it has no current intent to implement PSR. However, CSX, Norfolk Southern, UP, and KCS have all taken various steps. Exactly how they intend to implement it, I can't say that they're all going to implement it the same way that UP has been doing so. And we do know that the Canadian railroads were the first to implement PSR. CN and CP have been operating in PSR for many years now.
comment came in, some kind of a suggestion here about whether or not, from the reasonableness perspective is how I'm interpreting this, that tariffs should include longer lead times, longer notification times, if there's going to need to be infrastructure changes put in place to address these issues, new storage track, et cetera, that type of change should entail longer notice period, that 3 months would be inadequate. I think that's a perfectly reasonable point to make in testimony, that 3 months is insufficient and longer periods of time are needed.
We have another question as whether the STB can mandate that rail carriers work through storage charges with customers who have utilized the yard for decades and then suddenly required to adjust their operation within 45 days notice. I think that's a variation of the question that Karen just answered. And I think that's clearly one of the issues the STB will have to grapple with. Because the changes that are being made are so radical and on such a constrained time frame that it becomes impossible for many shippers to comply with them and avoid those charges within a limited time. And that does go to the reasonableness. If a shipper cannot avoid the charges, no matter what it does, that may not be reasonable. The issue is going to be whether the STB will issue some sort of broad brush decision on those bases, or whether that has to be done on an individual case by case. I suspect the latter, simply because every shipper is not in the same situation vis-a-vis these new charges. While one shipper may be able to secure the storage track they need within the 45-day notice, another shipper may be in a region of the country where capacity for storage track is very tight and could not. And therefore, what may be reasonable for the shipper that can comply on a short time frame is not reasonable for the other shipper. But that would have to be addressed on a individual complaint basis, however, rather than a broad brush decision. And certainly is not something I see coming out of this hearing. Rather, it might be part of any rulemaking or policy proceeding that might result from this hearing.
Okay, we don't have any other questions. We're going to give you another opportunity. If you want to, type in your questions in the pane. We've got a little bit of time left. If you have any more questions, we're happy to answer them.
We have a question about Canada, and that some shippers are experiencing even bigger issues in Canada, and whether there's any indication that Transport Canada is following this. I suspect because PSR has been implemented in Canada for years, I'm not sure that Transport Canada is quite having the same interest, but honestly, I don't know the details of what Transport Canada is looking at.
We have another question that came in. If our clients testify at the STB hearing, how will the rail carriers view that? Have you seen retaliation in the past or any testimony the railroads view as negative? This is a common recurring concern, I guess, we hear about from our clients and from rail customers. I'll tell you, based on experience, we have not really seen this come to fruition, especially with respect to a hearing like this, where the STB, Ann Begum has indicated this is a very important issue. She is strongly encouraging participation by rail customers. Frankly, we think the railroads would be foolish to target those companies who step forward in response to this very specific request from the agency. And again, frankly, we just haven't really seen that happen, especially with this type of issue in a broad inquiry like this.
And I would add that we do have many clients who have been active in STB proceedings, testifying for years, if not decades. And I'm not aware that any one of them has ever expressed concern about having been retaliated for their testimony. And in fact, the fact that they are continuing to participate in STB hearings would suggest otherwise.
Well, we have, oh, I think we might have got one more here. Let's see. Let me scroll up.
I have a question about the UP not prepared for service charge, and wanting to know if this is a car specific or switch specific. The charge itself is car specific. It would apply to every car that is not prepared for service when UP shows up the switch. This charge does have certain nuances in which it might be reasonable in one context but not in another. For example, if UP makes a special trip out to your facility to pick up a particular car or group of cars that are not prepared for service when it gets out there, then yes, UP has been put to the time and effort and cost of coming out to your facility and not actually having the opportunity to provide any service. On the other hand, as is common in the vast majority of situations when a facility is switched, a shipper may be tendering multiple cars all at once, and maybe only one of those cars is not prepared for service. Okay, well, UP is still out there to pick up all the other cars. It's not incurring any particular cost or detriment as a result of one particular car out of, say, a dozen or even a half dozen that are not prepared for service. In that context, that charge would appear to be unreasonable.
We're not seeing any more new questions. We have just a couple minutes left. We'll give you a chance to submit that if you'd like to. So we're not seeing any new questions at this point, and we're so close to the top of the hour, we'll give you a minute back of your day. But really, we do want to thank you all very much for joining us for today's webinar on how to prepare for the STB's hearing on rail demurrage practices. We appreciate you joining us. As mentioned earlier, we will have a copy of the slides to you later today by email. And the webinar will be posted on thompsonhine.com in just a couple days with the recording. So with that, I'm going to say we wish you all a very great day, everyone. Thank you very much.